Hello, Sofa Squad. This is going to be a quick little update over here on the podcast channel, and this is going to be a case update for our lovely little friend, I guess, Sarah Boone. Maybe not a friend, but a person of interest, we'll call her. Now, if you keep in mind or remember, Sarah Boone was convicted of taking the life of her boyfriend, Jorge Torres, and she did this by essentially manipulating him into a suitcase and leaving him overnight, and he asphyxiated overnight. Okay, so there's that. Now, Sarah drugged this out for years and years and years, right? Okay, so now she is in appeals process, and she is firing up her old MO, which is blowing up the court systems and being like, why isn't anybody, helping me? I should be all the things front and center, blah, 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 blah. So she's essentially gone to the court and been like, hey, y'all, excuse me, pardon me, what's up with my appeal attorney? So what I'm going to do is I'm just going to read her letter, her notice of inquiry as it is, and we're just going to talk about it. It's very quick, so that's why I wanted to put it over here. It's like a quick little update. So it says, Sarah Boone, well, obviously state of Florida versus Sarah Boone. Notice of inquiry. Okay, comes now Sarah Boone appealant and respectfully moves this honorable court to please provide status of her court-appointed appellant attorney, Joshua E. Adams, ESQ, in addition to her inquiry as to the status of her pending appeal. In support, the appellant states the following. An order was filed with the Ninth Judicial Circuit by the Circuit Court Judge Michael S. Kranick, appointing appellate counsel on December 18th, 2024. Court-appointed appellate counsel Joshua E. Adams has sent a single basic introduction via inmate messaging to appellant on February 27th, 2025, asking if she had any information and to not hesitate to contact him with that. Number 3, the appellant has attempted to contact Mr. Adams via inmate messaging 5 times and sent 2 handwritten letters to his office in efforts to receive status of her appeal and to confirm receipt of her correspondence to ensure his representation was and is still active from no response from him. Number 4, to the present date of this inquiry, appellant has not received any type of response or correspondence in any form or manner from Joshua E. Adams, nor has any of her 9 third-party representatives on her behalf via email and phone calls, which go directly to his voicemails. Number 5, ongoing 7 months, appellant has received 1 message from her court-appointed appellant attorney, Joshua E. Adams. Number 6, appellant was recently made aware by a third-party representative that the court issued an order on June 13, 2025, with a 20-day due date, requiring an initial brief be filed or her appeal may be dismissed. Due to the complete lack of proper and effective communication from her court-appointed appellant attorney, the appellant's appeal is now in jeopardy. The failure of an appointed attorney to perform duties or communicate with their client cannot be held against the appellant. Dismissal of an appeal under these circumstances would be an obvious denial of her due process and effective assistance of counsel. See Pullen v. State 802 SO 2D 113, Florida 2001. And it quotes, the failure of appointed counsel to act cannot be imputed to the defendant to justify dismissal. See also Edge versus State, and she lists the information. Number 7, appellant further invokes Douglas versus California, which guarantees the right to counsel on a first appeal as of right, and Adderson versus California, which outlines the duty of appointed appellant counsel to support the appeal or withdrawal following proper procedures, neither of which have been followed here. Appellant respectfully requests this honorable court to please advise and take notice of these violations and to either compel court-appointed appellant attorney Joshua Adams to fulfill his legal duties and communicate immediately, or appoint with new counsel capable of necessary communication and representation and inclusion of the appellant. Dated this 24th day of June 2025. Respectfully submitted, Sarah Boone. Okay, so let's talk about that for a second. Obviously, this is just, regular Sarah MO stuff, right? This is nothing to see here, folks. Now, I'm going to say a couple of different things about this. Number one, I think that Sarah, we have learned, Sarah has some expectations that are a little bit abnormal for her situation, especially now that she's been convicted. So now I will give her this much. I understand the frustration that she experiences, as well as we hear this from other people too, of no communication, this and the other, blah, 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 right? I can appreciate that that would be concerning with what she's outlined. There's due dates, there's this, there's that. My guess is this. She has a reputation, right? So this attorney, they're not going to sit here. They've got 10,000 things going on. One of those things that to be added to the list is not to handhold Sarah and write back and say, we're letting you know date of submission, blah, 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 blah. It's like, do you want me to spend my time hand-holding you, or do you want me to fight your case, right? Because the both of them aren't going to happen. They know she's not going anywhere. She's where she's at. They will address her when they need to address her, right? Her need to act all of a sudden, it's almost like she got sober and was like, I'm going to be an HR manager, right? And I think, did she do that at some point in her life, like something with human resources? So it's almost like that's the shtick she's playing in prison, is that, you know what I'm saying? And it's just like, that doesn't work that way. This isn't how this goes. You're convicted. It is what it is. They're going to get to you when they get to you. And unfortunately, it is what it is. Now, also, I get everyone has the right to appeal. This is standard protocol. There's nothing to see there, in my opinion. What is interesting to me also is when she says third-party representative, to me, that's giving a friend, right? Because remember how she'll try and make things way bigger than they really are? Now, again, do I personally know? No. Is that sofa speculation? Yes, right? Don't know, okay? That's just my speculation. Remember, she had that one friend who I think that friend is passed at this point, who was at court. But yeah, this is just her thing. This is what she does. This is what Sarah does. Now, I'm sitting here looking at this too. So, she's in the Ocala, Florida, whatever. I used to live in Gainesville many years ago. And I'm just like, oh my God, that's so creepy to think that that's where she's at, right? It's like almost like one step closer to her. It's like I know the area she's at. It just feels weird. So we'll see what happens with this. But again, I just think Sarah's going to be Sarah, and that this is what will go on forever. Clearly, she's not in the limelight as much anymore because her case is over with, and that probably absolutely pains her, because I think the worst thing that can happen to people like her and Lori is to be forgotten, right? Sarah doesn't want to be forgotten about. She wants to go down in HR history. So we'll keep up with the updates as we go. I do appreciate you watching. If you could, drop a couple of comments off down in the comment section below. And until we go around these little hot updates out the press, I'll see y'all soon.